Yes po. Good evening po, Mr. Atienza po. Atienza po. Good evening, ma'am. So, the case of Picop Resources Incorporation versus Base Metals Mineral Resources Corporation. So, this case is about the validity of the prohibition of mining operations relative to the classification system under the old NIPAS Act. Primarily, this case involves three entities: the petitioner Picop Resources Incorporation, the respondent Base Metals, and the Banahaw Mining. So, for the facts of the case, Banahaw Mining filed applications for mining lease contracts over the mining claims with the Bureau of Mines to extract and dispose of precious minerals found within its mining claims. Since a portion of mining claims of Banahaw Mining was located in petitioner Picop's logging concession in Agusan del Sur, Banahaw Mining and the petitioner Picop decided to enter into a Memorandum of Agreement or MOA, whereby the petitioner Picop allowed Banahaw Mining an access or right-of-way to its mining claims. So, Banahaw Mining converted its mining claims to applications for Mineral Production Sharing Agreements or MPSA. While the MPSA were pending, Banahaw Mining decided to sell or assign its right and interest in favor of the herein private respondent, Base Metals Mineral Resources Corporation or Base Metals for brevity. Meanwhile, the Base Metals amended the pending MPSA applications of the Banahaw Mining with the Bureau of Mines for the purpose of substituting itself as an applicant and to submit additional documents in support of the application. Now, the petitioner Picop filed with the Mines Geosciences Bureau or the MGB an adverse claim or opposition to the application of the Base Metals, in which Picop invokes several reasons, which are it violate the non-impairment clause and will be prejudicial to the petitioner. It further asserts that its concession areas are close to mining operations because these are within the Agusan, Surigao, Davao Forest Reserve established under Proclamation number 369. Another is that the area is allegedly part of the permanent forest established under the RA 3092. And the one related to our discussion is that the said area overlaps the wilderness area where mining applications are expressly prohibited under RA 786 or the NIPAS or the old NIPAS Act. That is why the area is close to mining operations specifically under the section 19F of the RA 7942. So the issue that was raised and resolved by the Supreme Court in this case is that whether or not the area covered by the MPSA of the Base Metals is close to mining activities. So the Supreme Court, speaking through Justice Tinga, ruled in the negative. It says no, declaring that Picop failed to present any evidence that the area covered by the MPSA is a protected wilderness area designated as an initial component of the NIPAS pursuant to a law, to a presidential decree, presidential proclamation, or executive order as required by the RA 7586. Although the said area status and clearances, particularly those pertaining to the MPSA, state that the portions thereof are within the wilderness area of Picop, there is no showing that this supposed wilderness areas has been proclaimed or designated or set aside as such. And pursuant to a law, it should be emphasized as well that it is only when this area has been so designated that Section 20 of RA 7586, which prohibits mineral locating within protected areas, becomes operational. And from that, there is clearly no merit to the contention of the herein petitioner Picop that the area covered by Base Metals MPSA is by law close to mining activities. It is also noteworthy for us to be informed that the National Integrated Protected Area System or the NIPAS Act is a system of classification and administration of designated protected areas to preserve genetic diversity. So in consideration thereto, and as a wrap up of this case, the underlying doctrine that we should remember which we can also infer from the very definition given for the NIPAS Act that we have just mentioned, is that clearly there must be a classification that an area is considered as a protected area. Meaning to say, the classification is essential, and without this proclamation or classification pursuant to a law, the prohibition of mineral location will not be operational. So that's the case po of Picop Resources versus base metals.